Let's take a look at judicial review in administrative law. The courts are generally viewed as essential to subordinating administrative action to the rule of law. They provide a check against abuse of administrative discretion and unconstitutional, illegal, irrational, or procedurally irregular decision making and enforcement. They are a full-fledged part of public administration and often considered partners, or more likely, senior partners with administrators. Judicial review takes place within federal and state court systems. These generally have well-defined division of labor among trial courts, appellate courts, and specialized courts. The district courts are the workhorses of the federal judiciary. There are 89 district courts in the United States. The district courts can resolve administrative cases in several ways. First, they could rule that an administrative action is legal. Alternatively, they could find that the action is illegal or unconstitutional. When ruling against the government, the district courts can block further enforcement of an administrative rule or order. They can also remand cases or send them back to the agency for further rulemaking, clarification, or adjudication. Short of resolution, the courts can also issue temporary restraining orders to prohibit the continuation of a challenged activity while a trial is held or a final decision is reached. They can also dismiss a suit because it fails to constitute a case of controversy within the meaning of Article 3 of the Constitution, lacks substantial federal legal question, or is otherwise not suitable for judicial resolution. Judges explain the legal and logical basis for their decisions in written opinions. Though these are not necessarily published or widely circulated, written opinions are central to the judicial accountability and the evolution of U.S. legal doctrine. Appeals from the district court decisions usually go to a court of appeals, though decisions in a three-judge case may be appealed directly to the Supreme Court. The courts of appeal are organized by circuit. There are 11 numbered territorial circuits. Appeals courts serve as a check on the district courts. Even though only a limited proportion of the cases are appealed, the possibility of review probably enhances the quality of district court decisions. As with the district courts, appeals court decisions are written in the form of opinions. They can create a number of outcomes. The Supreme Court sits at the top of the federal court system. Its most important jurisdiction is appellate, that is, it hears cases brought from the lower federal courts, primarily the appeals courts, and from the state Supreme Courts of their equivalents. It possesses original jurisdiction to act as a trial court only in a limited range of cases, such as controversies between two or more states. The court has a very broad discretion to pick and choose among the roughly 7,000 petitions for review it receives annually. Original jurisdiction aside, Supreme Court case outcomes parallel those of the appellate courts. The court can affirm or reverse the lower court, vacate judgments, remand for further action, and clarify legal questions. Its decisions are by majority vote of the justices who hear a case, which is usually the full body of 9. When a majority of those voting subscribe to a single written opinion, it becomes the opinion of the court. Supreme Court, district, and appeals court judges are appointed by the President within the advice and consent of the Senate. They hold office during good behavior and removable only through impeachment and conviction. These are called Article 3 judges because their authority and appointments are governed directly by the Constitution's third article dealing with the federal judiciary. The federal courts are a powerful component of government and a major institutional force in administrative law. Judicial review in the United States has at least two meanings. One is the power to declare government actions unconstitutional and therefore null and void. Another meaning of judicial review concerns what it is that the courts will review, when, and how. Article 3 courts cannot give advisory opinions because, constitutionally, their power is confirmed to resolving legal cases and controversies. Reviewability analysis is infused with constitutional considerations and prudential interests driven by the scope of judicial authority under Article 3 and the separation of powers. These are embodied in the principles of primary jurisdiction, exhaustion, and finality, and doctrines regarding federal judicial deference to state courts. The scope of judicial review refers to the depths of the court's probe in administrative action. It establishes the extent of judicial deference to administrators' expertise and their need for flexibility. It also defines the quality of the partnership between the courts and the agency. The more deferential judges are, the greater discretion agencies have in formulating and implementing their policies and programs. A limited scope of review discourages litigation and reduces the judiciary's role in public administration.